I will be talking about mens rea today. The Latin word mens rea translates into guilty mind. Mens rea hasn't always been a factor in the justice system. Before the 13th century, a person could be held criminally responsible regardless of intent. From the 13th century and forward, mens rea has become an important part of criminal liability. Mens rea is incredibly complex due to sizable number of levels of intent. Before I go into intent and why it's important, one must understand the difference between traditional mens rea and statutory mens rea. The distinction between traditional and statutory can decide whether the offender is held liable for the crime. Traditional mens rea is looking at the offender's level of blameworthiness for a crime. Throughout history, mens rea would look at the evil side of an offender. Typically, the words wicked, sinner, and even vicious were used to describe the mens rea part of the crime. Today, the mens rea part of the crime is more of a legality than actual moral ideologies. Statutory mens rea is actually quite different from traditional mens rea. In order for the offender to be held criminally liable, the prosecutor must show that the defendant intentionally committed the crime. Under statutory mens rea, if the defendant argued that he or she didn't know that the criminal activity that took place was illegal, it wouldn't matter. It's difficult to prove that someone intentionally committed a crime when he or she is stating that they didn't know it was illegal. Going back to traditional mens rea, if he or she didn't know it was illegal, does that make them evil or wicked? Is prosecuting them for the crime the right and moral thing to do? There are several terms that have been used in criminal codes that are in reference to mens rea, and the book goes over 5 of them. The first term is intent, which could be considered the most straightforward and important of the terms. Intent in criminal law means that whoever purposely commits a crime must be held liable for it. There are several different types of intent. The first is direct intent, when someone wants a specific consequence to happen and commits a crime to achieve that motive. An example of direct intent is if someone crashed their car purposely in order to collect the insurance money from the accident. The person intentionally crashed their car to ensure that the insurance company would total out the car, following that he or she would most likely get a monetary settlement from the insurance company for the damage. Unfortunately, with every situation, there are circumstances that one can't predict. There is something called transferred intent, and I'm going to continue to use the example that someone crashed his or her car for an insurance settlement. If that person crashed their car and only meant to hit a telephone pole to ensure no one else got injured, but instead hit someone else's car and they were hit and they were injured, now there is a case for transferred intent. Additionally, there is also general and specific intent crimes. General intent is associated with actus rea, the Latin term for evil act. This means that the prosecutor wouldn't have to argue mens rea for the crime potentially committed. Examples of general intent are battery, assault, rape, and manslaughter. Specific intent is committing the crime and knowing that what he or she is doing is illegal. For it to be considered specific intent, the crime must have been premeditated, knowing that what was going to happen was going to be illegal. Examples of specific intent are burglary, murder, larceny, and child molestation. Knowledge is the next term and is different from intentionality, intentionally committing a crime. Knowledge can be a requirement of mens rea for certain offenses. Knowingly is also a term that can meet the mens rea requirement. The prosecutor must prove that the defendant knowingly committed a crime yet ignored the fact that it was an illegal act. If the defendant committed the crime and willfully decided not to learn the truth or committed the crime with knowledge that it was illegal, the government can find the defendant guilty and convict him or her. A term that is often used in criminal law is negligence. Negligence means that a person willingly ignores a known risk or ignores the life and safety of others. The person is assuming that there is no potential for any type of harm to occur. While intent is someone acting on purpose, negligence is the opposite. Someone just doesn't see the risks in his or her actions. In order to prove negligence in the court, the defendant or the defendant's attorney must prove that he or she is mentally stable and can demonstrate duty of care. An example of this is an Uber driver must obey traffic laws and drive safely in order to keep his or her passengers safe and avoid unnecessary accidents. Recklessness, which is similar to negligence, only more serious in the eyes of the government. Recklessness is when someone knows the risks and the potential danger but commits the act anyway. An example of reckless behavior is if someone is drinking and then proceeds to drive home, knowing the risks of driving while intoxicated and how dangerous it can be. Recklessness can be hard to prove in court. It requires proof of substantial risk and that the defendant was aware of the risk. Another problem that could arise is if the risk can be justified. Examples of risks that can be justified are self-defense, protecting others from harm, or protecting your personal property. The last term is malice. It means having the intent to commit a wrongful act without a legitimate cause or excuse. There are two types of malice, express and implied. Express malice is deliberately doing something unlawful. An example is when someone intends to cause harm or death to another. Implied malice is when a person commits a crime without being considerably provoked. Depraved heart murder goes hand in hand with implied malice. Depraved heart murder is when an individual acts with no regard to human life, even if death occurs and the individual had no intentions of killing somebody. An example of this is when someone is committing a felony and an innocent bystander gets murdered. The person committing the felony didn't go out of their way to kill the bystander, but because he or she was committing the felony, they knowingly put that person at risk. These are all important terms regarding mens rea, but being able to prove mens rea in the criminal court is the bigger battle. Even if someone has mens rea to support a criminal conviction, the prosecutor still must prove it beyond reasonable doubt. Unfortunately, no one can read the mind of the defendant and prove what he or she was thinking while committing the crime. If the jurors find reasonable doubt after all the evidence is put forward, the jurors will acquit or, if possible, find the defendant guilty of a lesser crime. Next, I'm going to talk about the Model Penal Code. The code recognizes 4 different levels of mens rea. The first one is purpose, when a person acts purposely knowing that a certain result will follow. The Model Penal Code states that purpose is the most blameworthy state of mind. Knowledge is next, and it's when a person acts knowingly that his actions are criminal or that his actions will cause a harmful result. Recklessness is when someone acts recklessly and knows the danger and risk that will come from his or her actions. When someone acts recklessly, they do not have control of the end result, unlike someone knowingly or purposely acting. The last level of the Model Penal Code is negligence. When someone acts negligently, they aren't aware of the danger or risk that will result from their actions. The risk should have been known by the person committing the act. Someone who is mentally stable would recognize what they are doing could potentially cause harm to another human being. There are some cases where mens rea doesn't matter. A person will be held criminally liable regardless of the intent. This is called strict liability. Supporters of strict liability claim that there is a concern with promoting public safety and protecting people who cannot protect themselves. Strict liability laws were enacted years ago to protect workers and the general public from unsafe conditions in the workplace and in the community. Another positive point is that the penalties for these laws are minimal, and the supporters also believe that it's beneficial so the criminals don't escape punishment by deceiving the jurors with their lack of intent stories. The other side to strict liability laws are the critics. They believe that strict liability eliminates one of the fundamental principles of criminal liability, mens rea. In regular strict liability offenses, there is a possible evidence that laws are not being enforced enough, and the people that these laws are intended to target would routinely receive opportunities to correct their ways. The book gives 3 examples of strict liabilities: statutory rape, selling alcohol to minors, and traffic offenses. Lastly, I'm going to talk about concurrence. It's no surprise that actus rea and mens rea occur together, which is what's known as concurrence. There are 2 types of concurrence: temporal and motivational. Temporal concurrence means that mens rea must accompany the actus rea in time. Motivational concurrence requires that mens rea be linked to the actus rea it is intended to accompany. The mens rea is the motivating force behind the actus rea. Mens rea has been around for a long time and is one of the most important factors in the criminal justice system. The prosecution has to prove beyond any reasonable doubt that the defendant committed the crime, and establishing mens rea is necessary to prove guilt in criminal trial.